Digital money, control, and constitutional risk. You are asked to assess claims that the financial system is shifting from currency to code as a tool of control. You must separate verifiable law and institutional design from allegation and conjecture, and then evaluate the civil liberties and constitutional risks. The core question for you is whether digitized money and data infrastructures can be used for granular surveillance, constraint of movement, and automated punishment, and what legal safeguards would be needed to prevent that outcome while preserving payment efficiency. Footnote. This section frames your task as a legal evaluation of digital money as a potential control system and the safeguards it would require. Executive summary. You confront three linked propositions. First, public and private payment rails are becoming fully digital, which enables identity-level monitoring and rule-based enforcement. Second, financial intermediaries can cut access to accounts and services, raising due process questions, especially where government policy influences private action. Third, secrecy norms in national security finance and international central banking bodies can weaken accountability. Your response should be grounded in constitutional structure, administrative law, anti-money laundering statutes, and competition policy, with practical guidance on risk management for citizens. Footnote. This section distills the claims into three testable issues for legal and policy analysis. Digitization of money and control systems. You should assume that commerce is moving to always-on data layers. Digital payments tied to verified identity enable real-time surveillance and automated rule sets. The legal question is not whether code can do this, but whether the use of code is bounded by statute, judicial review, and democratic oversight. You must examine notice, appeal, and proportionality when rules affect individual access to money. Without due process, a payment network becomes an instrument of discipline rather than a neutral rail. Footnote. This section explains how identity-linked payments can become enforcement tools unless constrained by due process. Individualized surveillance and AI enforcement. You now live in a world where firms and public bodies can target one person at a time. AI systems profile, nudge, and throttle access. If those systems also gate payments, you face a merger of speech control, movement control, and economic control. You should evaluate requirements for human-in-the-loop review, audit trails that are discoverable, and liability when models are wrong. The legal standard must ensure transparency that is meaningful to the affected person. Footnote. This section sets out safeguards you need for AI-driven financial controls, including auditability and human review. Central bank digital currency and rule enforcement. You may encounter proposals for a retail central bank instrument. A programmable liability of the state can embed constraints on where, when, and on what you may spend. If adopted, you must require statutory limits that forbid content-based discrimination, viewpoint discrimination, and extra statutory sanctions. You also need independent oversight, narrow purpose binding, and hard limits that cannot be changed by administrative memo. Absent these, programmability becomes policy without legislation. Footnote. This section warns that a programmable public money must come with explicit statutory guardrails to prevent policy by code. Debanking, federalism, and state responses. You have seen account closures for perceived legal, reputational, or policy risk. When deplatforming is encouraged by officials, the line between private choice and state action blurs. You should analyze equal access duties in essential facilities, state statutes that bar viewpoint-based debanking, and federal preemption. Federalism allows states to protect residents, but uniform national rules may be required to prevent a patchwork that chills lawful activity. Footnote. This section addresses when debanking implicates state action and which level of government should set neutral access rules. The Bank for International Settlements and Immunities. You may review a body that facilitates central bank cooperation. Its legal status includes immunities under host arrangements, which can limit ordinary jurisdiction. Your task is to distinguish institutional coordination from unaccountable policy making. You should examine how domestic parliaments retain budgetary control, what disclosures are public, and how national courts treat actions that affect citizens. Immunity should not equal impunity. Footnote. This section explains how international immunities interact with domestic accountability and why oversight still matters. Monetary policy, fiscal policy, and inflation drivers. You must separate the tools. Monetary policy governs the issuance and price of central bank money and credit conditions. Fiscal policy raises revenue and spends it. Inflation can arise from excess nominal demand or from real supply shocks such as energy costs and fractured trade. Your analysis should focus on how rule-based instruments handle each channel and the distributional effects that follow from choices made by officials. Footnote. This section clarifies the different levers that move prices and the legal actors responsible for each. Deglobalization and supply chains. You should plan for price pressure when supply chains shorten or break. Sanctions, export controls, and security reviews change cost curves. The law must balance resilience with competition and consumer welfare. You can advise on targeted relief that does not turn temporary scarcity into permanent protection of inefficient structures. Footnote. This section links rising prices to supply chain redesign and the need for careful legal calibration. Space, satellites, and control infrastructure claims. You are told that space systems enable global telemetry and control. Satellites do enhance navigation, timing, and communications, which in turn support finance and enforcement. Your inquiry should remain evidence-led. Where public money builds such networks, you must insist on procurement transparency, privacy by design, and clear prohibitions on non-judicial tracking of individuals. Footnote. This section treats space-based networks as dual-use infrastructure that requires strict civilian safeguards. Underground installations and continuity projects claims. You may hear claims of extensive underground facilities and transport links. Continuity of government planning is long-standing. Your approach should focus on budget law, appropriations control, and the right to information. If facilities exist, the public deserves clarity on scope, cost, and lawful triggers for use, with independent inspection that respects security. Footnote. This section directs you to test claims through appropriations oversight and lawful transparency rather than speculation. Breakthrough energy claims and governance risk. You are presented with assertions of non-public energy technologies. Your duty is to demand reproducible evidence and safety regulation before deployment. If classified research exists, you must weigh national security against democratic legitimacy. The rule remains the same. Secrecy may be necessary for a time, but permanent secrecy erodes consent and markets. Footnote. This section sets a standard of proof and public interest review for any claimed novel energy system. Secrecy, public accounts, and statement standards. You should scrutinize accounting standards that permit redaction for security. Security exceptions must be narrow, time-bound, and reviewable. When material lines in public financials can be altered or withheld, investor protection and democratic control suffer. You must propose independent auditors with cleared status, dual ledgers that reconcile in closed session, and scheduled declassification. Footnote. This section argues for tight limits and oversight when public accounts include classified adjustments. Debt, health, and the cost structure. You are told the debt is a symptom of deeper cost drivers. Health burdens, fraud, and low productivity inflate budgets. The legal levers include truthful labeling, environmental enforcement where toxins drive illness, antitrust where market power inflates prices, and payment reform that rewards outcomes. You reduce fiscal strain by changing incentives rather than by financial engineering alone. Footnote. This section links fiscal stress to structural costs that law and regulation can attack directly. The red button thought experiment on illicit finance. You must confront a trade-off many avoid. If stopping illicit flows would lower asset prices or slow public spending, would you still act? A rule of law system cannot finance itself on crime while claiming virtue. Your task is to design transition plans that replace dirty flows with clean revenue, tighten beneficial ownership rules, and protect social stability during cleanup. Footnote. This section insists that you pair enforcement with credible transition so lawful finance can replace illicit subsidy. Practical risk management for citizens. You can reduce personal exposure with diversified custody, written escalation rights with banks, opt-in privacy tools that are lawful, and savings that adjust for inflation. You should invest in living equities such as health, skills, family, and community networks, because these are resilient when systems fail. You keep records, you learn the appeals process, and you act locally where your vote and voice matter most. Footnote. This section offers steps you can take to remain resilient within a digitized financial system. Conclusion: free society or control grid. You now see the fork. Payments can be efficient public goods, or they can become programmable restraints. The difference is law you can read, oversight you can trust, and remedies you can invoke. Your task is to insist on narrow powers, transparent budgets, and due process that travels with the person into any digital future. Freedom requires it. Footnote. This section concludes that your freedom depends on enforceable limits that bind digital money to constitutional norms.